Hi, I'm Ellen Cookman, and I'm an estate planning attorney. I am not a family law attorney, but I'm very excited to introduce you to somebody who is. I just did an interview with Lydia Hsu. She's a family law attorney and a San Jose native who's been working in the family law field since 2009. She's very passionate in working with people in this transitional time of their life. She works with a broad range of clients and she's empathetic. I'm sure you can tell by the video. And she wants to make sure that her clients are aware of all their options. In addition to representing clients, she serves as a volunteer settlement officer for the court. So without further ado, here's my conversation with Lydia. And I like to call this Help, I'm Getting Married, Now What? We talk about all the different nuances that have that crossover between estate planning and family law. And hopefully you'll find this interesting. Lydia, thanks so much for coming and joining us on our channel.
Thank you. I'm excited to be here.
Yeah, you're one of my favorite family law attorneys. I have several favorites, but you're up there. And one thing is, I feel like you describe things so succinctly and clearly. And so I'm really excited to dive into different family law issues with you. Now, first, I'd love if you could just describe to us, what's the difference between a family law attorney and an estate planning attorney?
Sure. The way that I describe it to my clients is an estate planning attorney is typically dealing with incapacity and death and issues surrounding somebody's incapacity or death. Whereas a family law attorney, we typically deal with transitions while people are alive. So those transitions could be getting married or considering marriage or getting divorced, having children, making families, making your family larger or smaller.
Excellent. I love that. And sometimes I get a little bit upset because I would like estate planning attorneys to be called family law attorneys because we really are doing planning for the family. But I heard from another family law attorney who's like, we just make smaller families. I'm like, well, you can do that too. Different families, exactly. And so we work a lot together for those who don't know. Lydia, can you give us an overview of what's the difference between separate property and community property? I know I often describe this to my clients, but I always give them a caveat that it's really a family law attorney who should be explaining this.
Sure. Yeah. And that's the probably number one question I get is what is separate property? What's community property? How do things become separate or community? So separate property and under California law is anything that you have prior to the date of marriage, anything that you have going into the marriage. And once you get married as of the date of marriage, anything that you acquire is automatically presumed to be community property, meaning that each person in the relationship is entitled to 50% of it. And I say presumed because if you're able to demonstrate that something came from a separate property source, something that you had prior to marriage, right? Then it stays separate property. You don't enter into a marriage with $10 million and get divorced 2 days later and the other person takes 5 million of your 10 million. That's not how it works. So separate property during the marriage is anything that is either traceable to a prior separate property source or anything that you receive by gift or inheritance. Those remain separate property. Then the community property ends upon the separation of the parties. So if you become separated, which is a whole nother discussion, and we can have that maybe another time, the community stops. And then once again, things that you acquire become separate property.
Great. And I assume that this is really important because when somebody gets divorced, it's their community property, right? That's subject to division, not their separate property. Is that true?
That is correct. Although we still do say basically this is your separate property and now it's being given to you as your separate property, or you're receiving your separate property and confirming it. And that way there's no question about, okay, were there some assets that were separate? Why weren't they dealt with? So when people are getting divorced, we still deal with all of the separate property as well as the community property.
Okay, that sounds good. Okay. So let me give you some examples of clients who've recently come in and they have great questions for us. And I say, hey, you should talk to a family law attorney. Now maybe they can watch this video. But one situation is people come in and they say, hey, I'm getting married soon. Maybe they already have significant assets, or maybe they were married before and they want to protect their assets. They want to keep their assets separate. What do you suggest for them? What are their options?
Sure. There's a couple different things that they can do. So the first thing is they can just keep their assets separate and as shielded as possible. So what that means is you keep all of your separate accounts separate. You don't add or commingle. When we take something that's community property and we mix it with separate property, we call that commingling. So an example of that would be you're working during the marriage, your earnings during the marriage are community property. And so if you take that community property and you deposit into an account that has separate property, then you're mixing those assets. So one way to keep everything nice and clean is to keep everything completely separate. Have new accounts established once you get married. Any community property earnings go into those new accounts. Anything you had previously remains separate, and you don't add any monies to those accounts. You just kind of keep them sheltered. But another step that you have to take on top of keeping everything separate is keeping documentation showing that there is no community property going into those accounts, right? It's not just saying, yeah, I never touched them. You also have to prove up that those assets are your separate property. So that's the first way of keeping things separate, is just, literally keeping everything divided, keeping things in your name alone if you're the person who owns a separate property, and not mixing those assets with anything else. That also goes with paying for expenses for separate property assets. For example, you have a home, that's a separate property home that you rent out. The income that's coming in, you also keep that shielded. But then you also pay the expenses for that home with your separate property. Mm-hmm. If you take community property and you pay expenses for your separate property, again, that's commingling, and you could be creating some issues there when it comes to dividing that asset. Another thing that people come and talk to me about is a prenuptial agreement, right? They want to have something pretty clear that sets forth exactly what is their separate property and what is going to be community property. And it's not uncommon for couples to want to change what those rules are. So with the prenup, we can say, instead of everything being presumed community, everything is presumed separate unless we make it community property, unless we designate something as community property. So there are ways to change the presumption by agreement, and that's where those prenups can come into place. But also some people just want to say, these things are my separate and will remain separate. Everything else, I still want to follow California community property law. And that's something we can do in a prenup as well.
That's terrific. Wow. That's great. And, from a trust perspective, I feel like we also kind of follow that, where somebody can set up a separate property trust that
Correct.
just receives their separate property. And then they can also have a community property trust, right?
Yes.
So, and that can receive all the community property. But I love what you're saying about be careful not to use community property to pay down a mortgage on a separate property house or that sort of thing.
Exactly. And you mentioning separate property trusts, I will say every client of ours that gets a prenup, we advise them to also go and get a separate property trust. So that way, whatever's governing their assets while they're alive, they keep that same intent if that's what they want, to protect their assets if something was to happen to them.
Excellent. And I know from an estate planning perspective, then they get to decide where do those assets go upon their death, make sure that it avoids probate. It's like a revocable trust just for one person.
Correct.
Very cool. Okay, so I love that. So now let's say that somebody has gotten married and their spouse is saying, well, hey, honey, I love you. We're married. Let's make everything joint property. Let's mix it all up. Why don't you put my name on your assets? What are the pros and cons of that? Can you kind of walk us through that?
Sure. And that is kind of a loaded question because it depends on the asset and it depends on what happens. But one of the things that we see a lot of is one partner owned a house prior to marriage, right? And then the other partner moved in and they might have kept it in that first partner's name. But then now that they're married, partner one wants to put partner two's name on title. So that becomes tricky because the house itself is an asset that is considered a separate property asset, right? Partner one owns that house as their separate property. So they have a separate property interest in it. Upon putting the other partner's name on title, you're now changing that property from a separate property asset into a community property asset. But that doesn't extinguish the original separate property component, the separate property interest that partner one had. So now if these parties get divorced down the road, you're going to have this calculation where you're going to have to calculate what percentage is separate property and then what percentage is community property that's divided between the two of them. right? What some people don't realize is that by just putting somebody's name on title, you could be messing up that calculation quite a bit. It could be complicating things in the event of a divorce. Another thing to be concerned about is if you're using community property to pay down separate property, there also could be some sort of an interest that's being created there. So one of the things that we advise people to do is if they decide they want to transfer anything to the other person's property, the first thing they do is talk to a family law attorney to really understand, okay, what are the consequences potentially that could happen, right? Pros are great. Now one person who didn't have, this asset now earns an interest or gains an interest in this asset. Cons for the other person is, well, now you're losing a percentage in that asset, right? If things are not to work out. But then you're also adding that layer of complication for a payment of this asset. And how do we divide that? And those calculations can be costly in the event of a divorce. So we advise people that if they're going to do it, make sure the agreement is very clear about, okay, are we waiving our separate property interest or not? Do I still have a separate property interest, or am I saying, no, I want this asset to be treated as community property as if we had bought this house during marriage, right? As if it from the very beginning, it was all community, make it nice and clean and simple. Another thing that people sometimes consider is a postnuptial agreement, which can define, okay, well, we still want some assets to be separate. We want some assets to be community. We're already married. We didn't do a prenuptial agreement. And now we want to define, okay, well, this house is my separate property asset, but we're agreeing the community can pay for it, or whatever it is that the parties agree how they want to financially meld their lives together. We can flesh all of that out in a postnuptial agreement.
I love that. I know sometimes clients come in and they want to name their spouse or put their spouse's name on, because anything that's community property upon death gets a full step up in the cost basis. So it's good from a capital gains tax perspective, but for, losing out if you get divorced, boy, that sounds so complicated. I've actually had clients, you should know, Lydia, I've had clients get mad at me where they're just like, it's so easy, just put his name on there. What's the problem? And I'm like, I know that it's complicated, but I don't know why. So thank you.
Right.
For running us through that. That's super helpful.
Yeah, I will say, I've seen some horror stories where people didn't realize that just by putting somebody else's name on title, they were giving a big interest away, or vice versa, by not having the other person's name put on title, this home that they had lived in for 30 years, they weren't entitled to very much of it. Right. So it's definitely something that if you're going to be making financial decisions, you should definitely be talking to the experts to consider, well, what do we actually want from this situation?
Excellent. Wow. Thank you. Okay. So let's go on to the third scenario I see a lot. I represent a lot of married couples, and one of them will receive an inheritance, and they're thinking, what should I do with this inheritance? And this is kind of like the first scenario, but a little bit different. Any recommendations for them? What should they think about and consider with this?
Yeah. And so having the discussion here, it also depends on the type of asset, right? So if inheritance is an amount of cash, right? We received $60,000 in cash. We want to take that cash and now we want to update our family. We want to remodel our family home, or we want to put it into college for our kids, or whatever they decide they want to do with it. Cash is a little bit easier to define. And a lot of the times what I tell people is, if you are using separate property for a community purpose, just view it as you are gifting it to the community. So if that's not your actual intent, you do need to have a document that says, okay, we're putting $60,000 of my separate property into this house or into whatever it is that the two of you decide to do. But in the event of a divorce, I'm getting my $60,000 back, right? Making sure you have very clear agreements is always good. If it's something like cash, the other thing we see a lot is if you inherit a property, right? If we inherit a property, but now we actually are going to put community money into the property to fix it up so we can rent it out, right? And then that's another instance where the home itself is separate property, because inheritances are separate property. But if you're putting community money into the house, the community is getting a right to reimbursement for contributions to the home, as well as the appreciation that those improvements might bring to the home, right? So again, having a very clear agreement, and this would be in the form of a postnuptial agreement, having an agreement in place that says this is how we're dealing with it, or this is what we intend to do with it, it can be very important, especially if there's added layers of complication. If we're dealing with an asset like a house, if they're going to be renting it out, if there's going to be payment of expenses, that sort of a thing. But if we're talking about something more simple like cash or an account, stocks, the other option is really just to keep those separate, right? And not commingle. Again, not using separate property for community purposes or mixing it with community money, keeping it in an account all on its own. And also, again, keeping documentation showing that no community money went into that separate property account.
Great pointers. I didn't even know that you could do an agreement to say, I'm putting 60,000 in, but I want it back if we get divorced. I had no idea that was possible.
Yeah, and people don't really think about it until they're getting divorced, right? So when people come in and get divorced, the number one question we get is about the separate property and community property. What does that mean? And then the follow-up question is always, oh, well, way back when I did this, right? Do I get that money back? And a lot of the times it's very hard to trace, depending on the length of the marriage, how that, gift or money or whatever it was used, having documentation for all of that. So I always advise people, if you're in the point of transition of doing anything, again, make sure you're talking to the experts, and then making sure that you have the right documentation is important.
Wonderful. Yay. Okay, now, so last scenario. All right, so we're talking a lot about people getting married, people getting divorced. Now, what about people who choose not to get married, but they're living together, they're buying property together? I know my husband's brother was in this situation, actually. What should they be thinking about? Someone who, for whatever reason, or maybe it's a brother-sister, who want to invest in a property together. How should they do that?
Yeah. So in the situation where you have romantic partners who want to purchase a home together or have joint expenses, maybe they have a family together, they just for their own reasons have chosen not to get married, do advise them to still talk to a family law attorney, because you don't have the right to community property if you're unmarried, but you can enter into agreements for how your assets are going to be managed, and what we call palimony, right? So not alimony, which is for spousal support for married couples, but palimony, we're pals, we're partners. You can define how each of you is going to support each other, because there is no financial obligation. There's no requirement under the law for you to support a boyfriend, girlfriend, partner, unless you're legally married. So we can certainly draft agreements for what does that look like, right? What does it look like if we buy this house together? How are we going to pay for these expenses? A roadmap for your relationship, similar to what a prenup would do, with the exception that there is no community property that is created, because that only happens if you're married, but you can create joint assets, right? And we work very closely with estate planning attorneys when we draft these types of agreements, as well as real estate attorneys, because there are some situations that come up that we might not consider, because we do typically deal with couples that are married or getting married. But then on the estate planning side, there's differences, and tax implications when you have a married couple versus unmarried people who are just jointly sharing their wealth. So we can,
California property taxes.
Right.
Right.
And then also children, right? A lot of times people have children together and they may not be married. And so what does that look like? How do they manage kid expenses together? Even though they're not legally married, parents are still required and obligated to support their children. And then planning for what happens in the event of, right? If something was to happen, what happens to these children? That's where we send those clients back over to you to prepare some sort of, guardianship documentation.
Wow, so much to think about. Boy. Yeah. But no, I mean, this is so helpful to think, okay, when do you need to go to a family law attorney versus an estate planning attorney? How do all these issues come up? And I think you made such a good point, because they usually come up 20 years after the fact. Right. And by then it's kind of too late. So I think this is so good to think through. All right, this is money that I've just inherited. What am I going to do with it? And really spend that extra hours worth of time with a professional. Talk through, how do I protect this? What are my best options? I know that I love working in partnership with other professionals. So that's a lot of fun at our firm. And I believe you guys do that as well.
Yeah, we definitely do. Any client that comes in, we almost always advise them to speak with an estate planning attorney wherever they are in their life, because that's something that you always need to be planning for, whether you're single, married, divorcing, especially divorcing. You definitely want to make sure you're talking to somebody about how to protect for your future assets. We also refer a lot to financial experts, right? Because again, there's so much interplay between financial issues and how do you want to deal with them. We can't always advise on what's the best for their future. We can draft the documentation for this is what they want, but what they want also has to work for them in the future. So we love to work with other professionals to make sure that our clients have the right team to make the best informed decisions.
Awesome. Well, thank you so much for taking the time, Lydia. This has been so informative, and I'm sure everyone watching is going to applaud you, even though you may not be able to hear it right now. So I applaud in preparation, and I'm so grateful. And if someone would like to work with you, Lydia, how should they reach out to you?
Sure. So the best way to reach out is you can send us an intake on our website, Foster Sue, that's FOSTERHSU.com, or you can email us at info@fostersue.com.
Excellent. All right. Thanks again, and wonderful talking with you.
Thank you, Ellen, for having me. This has been fantastic.
All right. I hope you found this interview with Lydia interesting and helpful. I have a video on estate planning for widows, which is helpful when you're looking at estate planning and there are some family law issues. So I encourage you to go watch it now.